Ready to strengthen your reading comprehension? Take a listen.
Welcome to The Explainer. I am so thrilled you're here. You know, when most of us think about civil litigation, we immediately picture these dramatic courtroom showdowns, right? Surprise witnesses bursting through the doors, impassioned closing arguments, the whole shebang. But let me tell you a little secret. That is strictly for the movies. In the real world of federal civil litigation, cases are almost never won in front of a jury. They're actually won months, sometimes literally years, earlier in a high-stakes, highly strategic game of procedural chess. So today, we're taking a deep dive into the legal playbook. We're going to see exactly how master litigators secured their victories long before they ever set foot in a courtroom.
So it really begs the ultimate question, doesn't it? How do you actually win a lawsuit before stepping into a courtroom? Well, the answer lies entirely in mastering your pre-trial maneuvers. Make no mistake, this is the actual battlefield. It's all about how you gather your facts, exactly when you choose to strike, and how you box your opponent into a corner that they just can't escape from. If you master this pre-trial phase, the trial itself is kind of just a formality.
Okay, let's dive into our roadmap for today and see exactly how we gather our pieces and set up our endgame. First, we'll cover the anatomy of a deposition. Second, the strategy of timing. Third, pretrial strikes, specifically motions in limine. And finally, we'll wrap up with the ultimate endgame move, estoppel.
Let's move to section 1 and see how this all builds, starting with the anatomy of a deposition.
Picture this. A deposition might happen in a super boring, wood-paneled conference room with stale coffee, but do not let that casual setting fool you for a second. A deposition is sworn testimony from a witness outside the courtroom, and under the federal rules of civil procedure, what gets said in that room carries the exact same legal weight as if that witness were sitting on the stand in open court. The stakes are absolutely incredible, and every single word is on the record.
Now, we aren't just on some random fishing expedition hoping to catch a lucky break here. There are 5 highly strategic purposes for taking a deposition. Sure, we have the discovery of facts, but we're also using them for the preservation of testimony, just in case a witness suddenly becomes unavailable later on. We use them to set up impeachment traps if their story happens to change. We use them for trial preparation, where we're actively testing our legal theories to see if they actually hold water. And crucially, a devastating deposition is often the exact catalyst needed to force a settlement. If you expose a fatal weakness in that room, the whole case might just end tomorrow.
You basically have 2 different flavors of depositions, and you absolutely need to know which one you're walking into. First, you have discovery depositions. This is your broad net. You're casting it wide, aiming to uncover all relevant facts, even the incredibly unfavorable ones, so you know exactly what you're up against. On the flip side, we have trial, or de bene esse, depositions. These are surgical strikes. They're highly structured, completely focused, and used purely to preserve testimony for trial, usually because that specific witness isn't going to be able to make it to court.
Now, what's really interesting here is how this is all anchored by the landmark 1947 Supreme Court case, Hickman v. Taylor. While depositions give attorneys a massive amount of power, this historic case established some very firm boundaries. The court ruled that questions must be relevant to the case and cannot encroach on privileged matters. It was a huge statement providing protection against bad faith tactics and abuse. You can't just use a deposition to annoy, embarrass, or oppress somebody. There are strict rules of engagement.
And speaking of rules of engagement, I have a massive warning sign for you. Federal Rule of Civil Procedure 32. This rule demands absolute, unwavering vigilance. If there's a procedural irregularity or a problem with the way a question is asked during the deposition, you have to raise your objection promptly, right then and there. If you sleep on it and try to bring it up weeks later at trial, no way, it's too late. The right is completely waived. You either speak up in that conference room or you surrender that defense entirely.
Let's transition into our middle game. Section 2, the strategy of timing. In civil litigation, what you ask is really only half the battle. When you choose to strike is where the true tacticians shine. Under Rules 30 and 26, once the parties have conferred and discovery officially opens, it's generally open season. Attorneys don't need to run to the judge for a green light every single time they want to schedule a deposition, as long as they haven't maxed out their limits, which is usually 10 per side. But listen, just because you can depose someone immediately doesn't mean you should. And this brilliantly illustrates the optimal sequence of events. First, you receive the document production. You absolutely need that paper trail. Second, you subpoena third parties to get all those outside perspectives. Only then, at step 3, do you depose the plaintiff or your main target. Finally, step 4, you file your follow-up motions. Basically, you want to gather every piece of ammunition you possibly can before you ever confront the main target.
So the crucial point here is your ultimate goal, locking down the testimony.
If you follow that precise timeline and depose the plaintiff before they've heard what the other witnesses have to say, you pin them to a definitive version of events. If you wait until the end of discovery, opposing counsel has had months to review your evidence. They can subtly tailor their client's story to fit around all the inconvenient facts. You lock them down early specifically to prevent that shifting narrative later on. But remember, the judge is always watching. Historic precedents like Crawford L. v. Britton and Herbert v. Lando remind us of this fascinating dual reality. The Supreme Court absolutely hates trial by surprise, so they mandate that discovery should be broad and liberal. But judges are actively empowered to act as referees. If the burden or expense of a deposition outweighs its benefit, or if the timing is clearly just being used to harass someone, the court will step right in and shut it down.
Let's move into our endgame strategies. Section 3, Pre-Trial Strikes and the Motion in Limine.
Okay, so the discovery phase is over, the board is set, and it is time to start taking the opponent's pieces off the board before the jury even enters the room. A motion in limine translates literally to "at the threshold." It's a preemptive offensive strike, a vital procedural tool used to address and resolve evidentiary issues before they ever pop up during a trial. If you know your opponent has a piece of incredibly toxic, highly prejudicial evidence, you don't wait for them to blurt it out in front of the jury and then yell objection. No, you file a motion in limine to get the judge to ban them from even mentioning it in the first place.
But again, timing is absolutely critical. You want to file this strike immediately after the discovery cutoff date, and ideally no later than 10 days after that. The logic here is super simple. You now have the full universe of evidence sitting right in front of you. You know exactly what they plan to use. You have to strike swiftly so the judge actually has time to review the briefs and make a ruling before the trial clock runs out.
And we are anchored here by some very strict federal deadlines. Rule 6C demands 14 days notice, and Rule 12 insists that pre-trial objections happen, well, pre-trial. We even have case law lore going all the way back to 1874 with Doan v. Glenn, which established that failing to act promptly on procedural defects means you waive your right to complain about them. In civil litigation, the law heavily favors the diligent. Filing this early gives you a massive psychological advantage. Think about it. Even if the judge decides to delay their ruling until the middle of the trial, you've already won a huge battle. You've planted a seed in the judge's mind early on that your opponent's evidence is deeply flawed. You are forcing the other side onto the defensive before opening arguments have even begun. Finally, we reach our checkmate. Section 4, the final move, estoppel.
If discovery was about gathering your pieces and motions in limine were about clearing the board, estoppel is your ultimate checkmate move to box in a shifting opponent right before trial. Estoppel is fundamentally about fairness. It stops a party from arguing something contrary to what they've already firmly established. It's an affirmative defense, which means under Rule 8C, you have to formally declare this maneuver in your pleadings. But wait, what if you didn't realize your opponent was going to flip-flop until after discovery? That is where Rule 15A comes to the rescue. It lets you amend your pleadings, and courts will freely give you leave to do so when justice requires it. You just got to be timely about it. When we talk about judicial estoppel, judges use a very specific three-step sequential test to figure out if a party is playing fast and loose with the truth. First, the party's later position has to be clearly inconsistent with their earlier one. Second, they must have actually succeeded in getting a court to accept that first position. And third, allowing them to change their tune now would create an unfair advantage for them or a seriously unfair detriment to you. To show you just how powerful this is, check out this fascinating Supreme Court lore from a 2001 case, New Hampshire v. Maine. So, these two states were arguing over the boundary of the Piscataqua River. New Hampshire tried to claim a certain boundary line, but the Supreme Court literally blocked them using judicial estoppel. Why? Because years earlier, New Hampshire had agreed to a different boundary and legally benefited from it. The court basically said, look, you can't have your cake and eat it too. Letting them change it now would create a totally inequitable result.
It's really important to differentiate between the two main variations here. Judicial estoppel, exactly like that state boundary case, is designed to protect the integrity of the court itself. It prevents judges from issuing wildly inconsistent rulings just because a party lied. Equitable estoppel, on the other hand, protects you. If your opponent misled you during discovery and you reasonably relied on that misleading conduct to your own detriment, equitable estoppel is what stops them from springing the trap. So as we look back at the board we've laid out today, depositions locked down in perfect sequence, toxic evidence preemptively struck from the record, shifting narratives completely shut down by estoppel, it leaves us with one final vital question to ask ourselves when analyzing these strategies. Is your litigation strategy truly trial-ready, leveraging every single procedural tool at your disposal?
Or are you just playing checkers in a chess match? Thanks so much for joining me on this explainer, and I'll catch you next time.
I'm not here for second place, I want